All right, let's go on the record on cause number DC 204534, Richard Avenue LLC et al. Versus Rosewood Custom Builders LLC. Council, make your appearances.
Jed Martin for the plaintiffs.
Andy Crone for defendant Rosewood Custom Builders LLC.
Eric Scott for defendant JR's Demolition.
Okay. All right, so we have a number of hearings set for today. I don't know that we'll reach all of them, but we'll do our best. We'll start off, I guess, with the motion for continuance of the summary judgment filed by the plaintiff. Why don't you go ahead and proceed?
Yes, Your Honor. This suit was filed right in the midst of the pandemic. We have sent out written discovery. We sent out 41 requests for production. They objected to all 41 requests, and they produced about 15 pages of documents. We sent interrogatories, 24 interrogatories. They objected to 23 of the 24 interrogatories. They refused to answer 18 of the 24 interrogatories. And we have asked for deposition dates. They refused to give out deposition dates. We need about 4 months to do discovery.
Okay, response?
Your Honor, the first matter is we filed an objection to the notice of hearing on this continuance. We called your staff to confirm that it was untimely. It was served.
All right. That's denied. You can
Okay.
proceed.
With respect to the motion itself, the plaintiff's timeline is quite misleading. Briefly, the timeline is this, Your Honor. My client filed its answer on May 11th, served written discovery on the plaintiffs the same day. We gave the plaintiff's attorney extensions on June 9th, June 30th. Thereafter, approximately 2 months later, on August 20th, we filed a traditional motion for summary judgment. It wasn't until September 1st and September 15th, respectively, that the plaintiffs finally decided to serve their interrogatories and requests for production. More importantly, Rosewood's motion for summary judgment, as I'm sure the court is aware, is a traditional motion for summary judgment. It's based on legal principles and undisputed facts. So that is to say, no amount of written discovery or depositions is going to change anything. Even if it was
Mr. Crone, isn't it true though that it's pretty critical for the plaintiff to know in responding to the summary judgment the relationship between the two defendants?
That has the relationship is clearly established and not disputed. It's in fact some of our summary judgment evidence is
Mr. Martin, is that disputed or not disputed?
That's disputed, Your Honor.
It sounds like it's disputed.
Your Honor, if I can continue just briefly, the motion for continuance, first of all, is procedurally defective. It's not supported by an affidavit. It doesn't describe the evidence sought. It doesn't explain how it could be material. It doesn't show that the plaintiffs have used due diligence. In fact, the record shows quite the opposite. They've exercised no due diligence.
Your Honor, the motion for continuance is verified.
And as I understand it, let me just kind of figure out what exactly is going on here. So you said have you responded to their discovery now?
We did ahead of its due date.
I'm talking to Mr. Martin.
Oh, I'm sorry. I apologize.
Mr. Martin, have you responded to their discovery?
Yes, I have, Your Honor.
And have you sent them discovery?
Yes.
And have they answered your discovery yet?
They have, again, they have not answered 18 of my 24 interrogatories. They objected to all 23 of the 24. So I have answers to 6 of my interrogatories.
And you've sent a request of depositions from them, is that correct?
Yeah, I have asked for depositions for some time now. They refuse to give deposition dates until after this hearing.
Your Honor, if I may, that's not accurate. So first and foremost, there's no motion to compel discovery from plaintiffs, despite the fact that we've already prematurely, in fact, served our answers. Second, we do have a motion to compel on the plaintiff's sufficient responses set for hearing. Thirdly, the request for deposition he's talking about is a corporate representative deposition that was not proper pursuant to rules, in that it didn't explain what he wanted to ask a corporate representative about. So we would have no way of identifying who or how many people would
Has he given you topics?
No, and we've told him that probably 2-3 months ago.
Your Honor, that's not true. I sent them an email saying it's the topics are identified in my interrogatories, my request for production. That the rule he's referring to is
Mr. Martin, you need to be more specific than that. I don't think you can just refer to the interrogatories and requests for production. You need to give topics.
Yeah, but Your Honor, this is not the actual deposition notice. This is just an email saying I need to have dates.
But you, in order for him to know, I don't know how big this company is, but in order for him to know who he needs to get, he needs some specificity on what you're requesting. So that being said, I'm going to grant the continuance, but I do want Mr. Martin for you to send him a request with topics that you want him to cover, not something that's a little more specific than what you've done. And then you need to get, you just need to kind of jump on this. So that deals with that issue. When do we want to, how many depositions do you need, Mr. Martin?
Probably 3 for sure, each defendant in the city of Dallas. It's going to take me some time to get responses to the written discovery because I'm going to have to file a motion to compel, I'm sure. I'd like 120 days.
What do you think, Mr. Crown?
I think that's absurd, Your Honor. He's shown no diligence in pursuing this case. You know, if you've read our motion for summary judgment, we're not even a proper party. The only reason we're in this case is because
I don't know that I agree with you based on what I read. It sounds like you hired a construction company to demolish a home and they demolished the wrong home. I don't know if that was y'all's fault or their fault, but I think you are going to probably be a proper party and you'll probably have to go to trial on this one if you don't settle it. This is pretty egregious that you guys destroyed the wrong house I don't know what the exact relationship between you and the demolition company is, but you destroyed the wrong house.
Your Honor, briefly, and maybe the demolition company's attorney can add to this to clarify, there is no relationship with respect to the destroyed house. The evidence attached to our motion for summary judgment very clear. We gave them pictures of the correct house. We had never heard of this house. We had never heard of these purported owners of this house. So, I mean, if we want to wait and do some discovery, it's not going to change anything. My concern, though, is Mr. Martin's, frankly, his behavior and manner of conducting himself in this case. How long are we going to wait to rehear these issues? And,
I don't disagree with that. I will say, just based on what I said, unless Mr. Martin just doesn't do anything, I can't imagine I would ever grant a summary judgment on this. But I mean, that's neither here nor there. I just, based on the facts that as I know of them, I just think that there's going to be a fact issue here. But that's, we can go through the process. So, Mr. Martin, you do need to, jump on this. You need to file a motion to compel against them. And if you haven't already tried to work it out, you need to try to work it out. And then if you can't, file a motion to compel. And you need to send him a list of topics on for the corporate rep deposition so that they know who they need to get. There might be more than one person. And you said you needed to depose someone from the city of Dallas. Why is that?
Well, the Rosewood Custom Home Builders LLC is saying they're not a contractor and they're not subject to the building code. So I'm probably going to have to take the deposition. They're also saying that everything in the building code isn't designed to protect homeowners. So I probably need to take a deposition of a Dallas city representative, say, yes, these building codes are in force and effect to protect homeowners. And yes, a contractor is subject to the building code.
Your Honor, the plaintiffs haven't even been deposed. And I don't know if we're going to get to our motion to compel discovery today, but that's the issue. That's why the court doesn't know what the relationship is or what the allegation is because the plaintiffs in their discovery responses copy and paste large portions of Mr. Martin's petition, and their answers are nothing but legalese. We asked them contention interrogatories, explain the legal and factual basis for your allegation that this authorized contractor, and they just copy and paste portions of the petition. That's why we can't get anywhere.
Mr. Scott, you represent the demolition company, is that right?
I do, Judge, and I didn't want.
Did your company just make a mistake and demolish the wrong house, or was it because of the something that Rosewood did?
It's my understanding, based upon my role in this case that they just simply had the wrong address. It was the wrong house.
Who did? That Rosewood did, or y'all?
My client had the wrong address. So my client is a subcontractor that was hired by Rosewood. It's an independent contractor relationship. It's not employer-employee. So that's the nature of the relationship. It's just a GC hiring a sub. In this particular case, my client was a demolition sub, thought it was at house A when it was mistakenly at house B, and house B is the house that Mr. Martin's clients owned.
So why haven't you guys tried to settle this? Why haven't you gone to mediation?
Well, Judge, it's been pretty early in the sense of the damage model is still very fluid. Mr. Martin's claims and pleadings continue to adjust, continues to add new claims, modify those claims. The damages are still, I think, very suspect. I don't know that any reasonable demand has been made up to this point. I mean, if the court wants us to take a down and dirty shot at a mediation before we spend money on depositions, I'm not opposed to that. I am concerned, though, that by the court's ruling today, you're going to tie the defendant's hands pursuant to some summary judgment motions. I heard what you said about under the facts as you know them, you're inclined not to grant summary judgment. However, I do believe there are certain causes of action that need to be erased immediately so we can streamline this case and just get down to what it's really about, which is what was the value of the property at the time it was demolished.
Mr. Martin, has your client made a demand yet?
We have not made a demand. Mark Gilbert's been appointed as the mediator. I think an early mediation is a great idea. I've got a client who is, we're willing to settle within policy limits, and we're not unreasonable. They get more and more mad every time, the defendants say they're not liable and things of that nature. So I think that time might be our enemy here in terms of settling the case.
Have you guys tried to schedule something with Mr. Gilbert? I know sometimes it takes a while because he's such a popular mediator.
I can call him today.
Your Honor, see, that's what myself and JR's counsel have been dealing with this whole time, is that over here in all these pleadings before the court.
Mr. Crone, let me just say this, and I'm not trying to give you a hard time, but Mr. Martin's client had a house. Just imagine if this was your house and you came home one day and somebody had demolished your home. I don't know. You're taking an awfully aggressive approach to this case when your client, I don't know what the possible defense is going to be for the demolition company. And we don't know at this point for sure if it was a problem with your client providing the wrong information to their client or their client just screwing it up. But
we do know that you're
don't interrupt me, please. You're playing this like you're some time a victim or that you've been terribly mistreated in this process. But your client, and maybe it was totally the demolitions company's fault, I don't know, but your client hired somebody who demolished the wrong house. These people are completely innocent here. So I'd urge you to take maybe a little bit less aggressive and confrontational approach here, and let's let the process work itself out. I think an early mediation makes sense. If they can work something out on this, I think that'd be great. But I think this hyper aggressive approach that you're taking here doesn't make a lot of sense given the facts of this case. And so I'd urge you to maybe let's let the process work itself out. I think an early mediation makes sense. Mr. Gilbert's probably one of the best mediators in town. Let's see if we can get that worked out. Let's put the summary judgment on the shelf for now. Get the mediation done. Mr. Martin, you need to get a demand over there. They can't settle this if they don't know what you're asking for. And let's get this thing done.
And just, Judge, if I might just interject one moment just to clarify while we're all here.
Sure.
Mr. Martin, are we going to go ahead and schedule this mediation without this 120-day time period to conduct depositions? Is that the goal here?
I don't know how long, Mr. Martin, how long will it take you to make a demand?
I would say by Tuesday.
Okay. And does anyone why don't I do this? Why don't I put you guys into a breakout room You guys, you guys see if you can get a mediator, as soon as possible. Maybe Mr. Gilbert, I don't know what his schedule's like. You might want to go with someone maybe a little less popular, because if it takes not saying that Mr. Gilbert isn't a great mediator, because he is a great mediator. I used to mediate with him when I was in private practice, but let's find one that can get you in a little bit quicker. And Mr. Martin, you do need to provide them discovery responses so that they can properly evaluate your case. That's
Well,
I'm not fussing with you, but I'm just saying this case should be pretty easy to get resolved, I would think.
yeah.
And let's give them a shot to try to settle it, give them all the information they need. If they come back and there's, I kind of agree, probably between the three of you, most with Mr. Scott, that this is really just a damages case, and we need to figure out what the damages are. And if your client makes a reasonable demand, it sounds like Mr. Scott's client hopefully will act in good faith.
Briefly clarify two things.
But Mr. Crown, I'm talking to Mr. Scott right now, okay?
Okay.
Mr. Scott, what do you think about that?
I am fine with an early mediation. I think if we're going to do that, we need to do it before. This is my personal opinion. I think we need to do it before we start the slippery slope of depositions of at least these three fact witnesses. I think there's enough on the table to at least understand what the general damages are. We don't need to worry about what happened. We know what happened. A house was demolished. It was a wrong house. Question is, what is that worth?
Totally agree with you. And I think in this particular case, it might make sense from a purely logical standpoint, what might make sense is you might have to take the plaintiff's deposition just on the issue of damages, but really, I guess you could just, what are they going to know about the liability? They were, as I understand it, were they even there when the demolition occurred?
No, Judge, the house was, as we viewed it, well, it was vacant. There's a dispute as to whether or not it was in the process of getting ready to be remodeled, or if it was vacant with an appearance of looking like it was ready to be demolished. That's one of the factual disputes between the parties. But really, like I said, it's a damage case, and there's a litany of intentional infliction of emotional distress claims and some other claims. But at the end of the day, it's really, what was the property worth before? What was the property worth after? That is how I'm viewing this case. And it's our intention, to the extent my client has the financial ability, to participate in any settlement in good faith.
And there's insurance coverage for this, correct?
My client's carrier has denied coverage.
Well, your client's carrier has denied coverage. What do you mean?
Well, we've submitted the claim we've tendered the claim to the carrier, and the carrier denied coverage.
Why?
They claim that it was damage to our own work. Believe me, I've done everything short of filing a lawsuit against the carrier, and that may be an option. But the problem is, my client is a construction company in the middle of this COVID crisis and doesn't have infinite resources available to it.
Your Honor, if I may, I've seen the denial, which Mr. Scott is correct. I think that denial is very suspect.
Well,
not genuineness. I'm talking about in terms of the position of the insurance company.
And I understand it. And these could be things we discuss at mediation, which could include some type of assignment of our rights against the carrier. There's a lot of options that are available to the extent everyone's reasonable.
I want you to put the carrier on. Have you thought about suing the carrier in this case?
I've thought about it, Judge. I just need to talk to my client to find out if they have the financial ability to pursue that claim.
Okay, that makes this all a little more complicated. I thought the carrier was participating in this.
Carriers denied that claim. And just for what it's worth, Judge, I've talked to a couple of friends in the industry, and from what they, insurance industry, and from what they're telling me, it's a solid denial.
Your Honor, Rosewood does have coverage.
Okay. All right. This all makes a little more sense why it's happening this way then.
Yes.
That's what I was afraid of. Okay. Well, given that, do you still want to do an early mediation? I didn't understand that to begin with. So do you still want to do an early mediation?
I still think it would be helpful, Your Honor.
Okay, Mr. Crone, you said you had two questions. What were your
Yeah, a
questions?
couple of clarifications that I think factually it's really important for the court to understand why the parties have taken their respective positions. One, now you see what the picture is on the insurance issue. You know, without going too far, I think Mr. Scott would agree with me. That explains a lot as to the aggressive attempts to tie my client to JR's. But the second thing, you asked me a moment ago how I'd feel if I came home, my house was destroyed. Factually, it's important to recognize this was a house owned by a company, owned by two individuals who live in, I believe, Los Angeles. They don't even live in Texas. Second, they acquired the house, my understanding, Mr. Scott could speak more to this, after being embroiled with litigation with the decedent's family, the person who owned the house before. This isn't like, you know, 70-year-old couple comes home to a demolished house. Nobody was living there. A company owned it, and its owners live in Los Angeles.
Okay. That's somewhat helpful, but
Your Honor, if I may, the people that bought it were personal friends of the decedent, and they had promised her that they were going to rehab the house. She was very active in the community in terms of not tearing down homes, not building mansions, things of that nature. And they had made a deathbed promise to rehab the home. And we had a contractor out there who had been doing work. We paid him $17,000 at the time of the demolition. They were rehabbing the house.
well, okay, I'm gonna leave it up to you, Mr. Martin. If you want to do an early mediation, I'm not as convinced that that's gonna work. I kind of think maybe you need to flesh out since Rosewood has the insurance here. Maybe you need to flesh that out, but I'm open to suggestions, Mr. Martin, if you want to do
Your
it.
Honor, I think that it's a good idea for the simple reason that I have two very emotionally charged clients. And I think that they are more susceptible to a settlement early as opposed to late.
Okay, it's fine with me. Do y'all want to, let me put you guys into a breakout room, and then I'm going to send Miss Simmons with you. Well, that's not going to work. I'll send Miss Lee. Miss Lee, you have my cell phone number, right?
Yes, sir.
Okay, go ahead and text me when you're done.
Yes, sir.
When they're done. Okay, so try to see what you can do in terms of setting up the mediation. And Mr. Martin, if this doesn't settle, then we're going to have to deal with these other issues. So,
Right.
All right, let me go ahead and set up the breakout room. Mr. Crone, Mr. Scott, Mr. Martin, Miss Lee. And then is the other gentleman that was the observer, what was his name? What, he left? Okay. Okay. Miss Lee, just text me when you're done, when they're done.
Thank you, Judge.
Thank you, Judge.
Good luck, guys. Okay, are both sides here on the JAG financial case?
Yes, Your Honor.
Believe so.
Okay, we're here on a motion to expunge or strike, is that correct?
Yes, Your Honor.
Yes, Your Honor.
Okay. Do y'all want a record for this?
No, Your Honor.
That would be great, Your Honor, if that's okay with the court.
Sure, let's go on the record on cause number DC 201463, JAG Financial Services versus Capital Asset Recovery. Counsel, make your appearance.
Constance Vroom on behalf of Mr. Glasscock.
Your Honor, good morning. Grant Schmidt on behalf of the car entities.
Is there another attorney that's supposed to show up for this, or is this it?
I believe this is it.
Okay, let's
And
proceed.
I'm sorry, this is the court reporter. Ms. Constance, can you say your last name again? I was looking at what was on the screen.
No, it's fine. It's Broome, B as in boy, ROOME.
Thank you.
You're
Okay,
welcome.
let's proceed.
Your Honor, I'm here representing Mr. Glasscock, and we're the ones who filed the motion to strike and expunge. The basis of the motion is that CAR and the two CAR entities have begun asserting all of these allegations regarding claims that he embezzled money from them. The problem is, though, that they're not seeking any relief in relation to those claims. They're also not asserting any sort of affirmative defenses that require any prospective use of the embezzlement. So from our perspective, given the fact that the claims relate to a breach of contract, there's really no relevance to make an allegation as to embezzlement. The embezzlement's not an issue, and they haven't put it at issue. There's no reason to address it, this allegation that he embezzled money, because a breach of contract issue doesn't have anything to do with what motivated somebody to amend a contract. The fact that there is a contract between Carr and my client, Mr. Glasscock, is at issue. The fact that they amended the contract in a way that violated the contract, it is at issue. The fact that they amended it for a reason over here that he allegedly embezzled doesn't have any basis. It's the fact that they amended the contract improperly. So to put all of this out there for a person who works in the financial industry, first of all, is extremely inflammatory and very harmful to him in a professional way, and it doesn't have any relation to the issues. So from our perspective, it's—
Why wouldn't you just do a 76A motion on the petition?
I'm so sorry, Your Honor.
Why wouldn't you just do a 76A motion on the petition?
That's a good thought. I haven't even discussed that. I'm new to the firm. Maybe Dana has thought about that and maybe she hasn't, but I'm happy to bring it up to her.
Okay. Mr. Schmidt.
Your Honor, may it please the court. Good morning. The court is hitting on the same issue that I was going to raise. I'm going to get into whether or not it is in fact relevant. It is, Your Honor, from our perspective, and we've asserted several reasons why in our briefing, but this motion seeking to delete words and strike words from the record and to forbid Carr from making arguments at this stage in the litigation. There's no authority for that under the law. In their reply, they don't cite a single case. They do make, Ms. Broom makes a relevance argument, which we can certainly have, Your Honor, but to strike words from a pleading, forbid the other side from making arguments at this stage would be an extreme remedy. Two quick points, Your Honor. The first is that it is relevant. Mr. Glasscock sued Carr for breach of contract, fraud, and breach of fiduciary duty. He said that he had not received distributions as a limited partner. In order to understand why he stopped receiving distributions from Carr's perspective, again, Mr. Glasscock is free to dispute this, and I anticipate that he will throughout this case. But in order to understand from Carr's perspective why that happened, the court already heard a little bit about this earlier in the week, so I don't want to reinvent the wheel.
No, I recall all of this. I mean, I agree with you. I don't, and to be honest, I don't know that anyone has ever made this type of argument before, where you strike a portion of a petition because it's upsetting or whatever. I have had situations, and I think it might be appropriate in this case. I'm not making any rulings, but to do a 76A motion, but and I would encourage you to kind of think about that. But but at this point, I'm going to deny the motion.
Understood, Your Honor, and I appreciate the directive on the 76A. We'll definitely look at that.
And Mr. Schmidt, I would encourage you to, and this isn't an order, it's just advice, is to the court will look with question upon if you oppose a 76A motion on something like this. I mean,
Totally understand, Your Honor.
so I hope that makes sense. So
Yes,
I'm
we're
not
on the
worried
same
about
page.
anything. I'm just, you're a very good firm, you're a very good lawyer, and so I just want to let you know what the court's temperature is on that. So
We're on the same page, Your Honor.
okay. All right. Thank you, guys. Mr. Schmidt, have you already submitted an order on this?
Yes, Your Honor, I did.
Let me just make sure I have it. Give me 1 second. As you can probably tell, I'm actually at the courthouse right now, so I need to see if I have this order. Let me see.
Judge, are you starting to have some hearings in person?
Very limited numbers. On show causes, we're doing those in person, but generally we're doing almost everything. I'm basically, if the parties would really need a hearing in person, then I'm willing to entertain that. But I would want to talk and figure out like how many people are coming and is it live versus live testimony versus non-live testimony. So generally the answer is I'm not having many. I've only had one so far, and I have one scheduled, I think, for next week. So generally no, but in limited circumstances, yes. But like this hearing, I would prefer to just do remote. There's
Right.
no reason we needed to come in person.
Right.
Hopefully it's more convenient to you. I do have the order. I just printed it out. I'll go ahead and sign it. It should hopefully be scanned by today or Monday.
Okay, thank you, Your Honor. Have a great weekend.
Good luck. Think about the 76A.
Thank you.
All
Thank
right,
you.
bye-bye. All right. Okay, what did you guys figure out on the mediation?
Judge, is this one on the record? Because I need 1 second.
Okay, yeah, I don't think you need this on the record, but if you want it on the record, you can. Mr. Martin is muted again. Mr. Scott, did you guys work something out on the mediation?
I mean, we did have a brief discussion, and I can't speak for Mr. Crone, but I think he's got some reservations about such an early mediation and the viability of his client's willingness to make any concrete offers at this time. But I'll let him talk to you about that. Andy, you're muted.
Yeah. Mr. Martin, are you there? Can you hear us?
Yeah, we're contacting Mr. Gill. We called his office. We're going to send him an email looking for some half-day mediations. As I indicated before, I've got a client who is more amenable to a settlement today than they will be several months from now. So I'd like to go at least give it a shot.
Okay. But you don't have any dates from Mr. Gilbert's office. Were you not able to reach them, or?
We called and they said, send us an email.
Send us an email?
That's what they said, yeah.
How would you all feel about mediating with Judge Ginsburg? He's generally pretty available.
I've never used him for mediation. I liked him as a judge, actually.
Mr. Crone, Mr. Scott. I mean, if you want to get in quicker, that's my only thought, because Gilbert, I've heard people say, can take months to get in.
I'm fine with Judge Ginsburg.
I have no specific commentary on Ginsburg. Finishing Mr. Scott's question to me, the concern is that, it seems based on the way this hearing's gone, that some more factual clarification needs to be done, because at this point, I don't think Mr. Scott can say that his client's going to have any amount of money that would make the plaintiffs happy. And I obviously haven't reported about this hearing to my client, but I suspect they'd rather try this case than pay these two owners any money based on the facts. So obviously if you order us to mediation, we'll do it. But, I just think there's some concerns there.
It's up to you, Mr. Martin.
I think we need to go ahead and give it a shot.
Okay. Let me call him right now. Let's see if we can get him. Get him on the phone. So you're thinking of maybe 2 weeks, because you said you can get a demand out by next Tuesday. Is that right? Would 2
That's
weeks
correct.
work?
Yeah, I would say anytime the following week in the afternoon would work.
You said in the afternoon?
Yeah, let me look here.
Judge Ginsburg, this is Judge Hoffman.
Yes, how are you?
Good, good. We have an emergency mediation that we need to schedule with you, and I just was checking your availability. It wouldn't be for next week, it would be for the week after. I was just wondering if you were going to be around and available.
Yes, I'm going to be around. Let me step over. Hold on, let me put my glasses on. That would help, wouldn't it?
Yeah.
Let me step over to the computer. And
Let me ask you another question just while you're doing that, because this is very likely to be the situation in this case. I'll explain to you very briefly what the facts are. Is that the plaintiff owned a home. They didn't live in it, but they owned a home. Their next door neighbor, I think, hired a demolition company, or hired a builder who hired a demolition company, and the demolition company tore down the wrong house. And but the problem we have is that the demolition company doesn't have insurance, and the custom home builder is claiming it's not their responsibility. I've told the attorney that I don't find that argument very persuasive, but he's very insistent that that's a good argument. So, but we haven't dealt with the summary judgments. I've continued the summary judgment. So anyway, the bottom line is the plaintiff wants to do an early mediation, see if we can't get this worked out. There is a possibility that we'll do an early mediation, and then it won't work. We'll have to do some more discovery and then do another mediation. What is your kind of policy on that?
I believe the policy is party driven, and if the parties want to do that, then give it a try. If they don't, not. It takes two to tango. So if they both want to do that, I would say, empower them to do it. Okay. That's my general attitude about it.
So we're looking at not this next week, but the week after. And they want to do an afternoon mediation. Is that correct, Mr. Martin? What days?
Yeah, the 19th and the 23rd in the afternoon that week.
My only caveat, Judge, is I'm not available I'm not available until the 21st.
So the 23rd, Mr. Scott?
No, the 21st. The
21st, 22nd, 23rd.
Yeah, Wednesday on.
Okay, and you said, Mr. Martin, you're available on the 23rd. Mr. Crone, are you available on the 23rd?
I am, but the other thing we need to discuss is I assume the court and Mr. Martin will want my client representative there, and so I obviously don't know their availability.
Let's go ahead and set it for the 23rd. And it's okay. In fact, I encourage you to do this remotely. But anyway, so hopefully they'll be available remotely at least. The cause.
Yeah, I'm sorry. As a practical matter with COVID, that's pretty much how everybody's been doing them lately.
Okay, yeah. So remote is encouraged, strongly encouraged. The cause number on this, Judge Ginsburg, is DC 204534.
I'm sorry. Can you repeat that, please? DC 20
4534.
4534. Yes, sir.
And then I remember you have a procedure where you want them to email you. Is that correct?
Yes, please. And that way I'll have their email and I'll send them back a confirmation letter. And once again, it's Carl, CARL @ GinsbergADRgroup.org, GinsbergADRgroup.org. I don't know if council can hear me in the background, so that's why I'm kind of slow in spelling it out.
Did you guys hear that?
Yeah, Carl at GinsbergADRgroup.org.
I said, I don't know why I said .org, .com. Excuse me, I'm having a senior moment here.
Sorry, it's .com. I think .org was our court email address. So, .com. So in the 23rd, what time would you like them to be there, Judge Ginsburg?
It's up to them. I'm pretty free that day, so I think they want an afternoon. Tell me when. Let me ask the parties when they want to do it.
How about 1 o'clock?
1 o'clock? Okay. So 1 o'clock, I'll send you all email me and I'll send back a confirmation letter. The Zoom instructions will be in the confirmation letter, and we can go from there. And hopefully we can get this resolved. We'll have a constructive conversation.
Yeah, I'm not, we'll see how it goes. We'll just,
Okay.
it may be a 2 mediation deal is my guess, but we'll see, and we'll hopefully get it worked out. So thank you, Judge Ginsburg. And if there's any issues with them showing up for the mediation, please let me know.
Okay.
All right. Thank you. Bye-bye.
Take care. Enjoy. Bye.
Okay. Let me know how he does. I've been sending him a couple mediations lately. Anything else we need to chat about today? Because I need to get to my next hearing.
I assume we're also holding off on the other motions, the discovery motion, the special exceptions.
Yeah, so Mr. Martin, I would just say, get them as much information as you can prior to the mediation. So that means get them a demand, get them as meant, I think they want to, or at least Mr. Scott wants information about what your damages are. And so try to get that all to them. I mean, it's pretty clear to me that this is just going to be a dispute, kind of a he said, she said. Does the jury believe Mr. Crone that, hey, look, we gave him all the correct information? Or are they going to believe the construction company? It does seem like this, just from my standpoint, it seems a little bit convenient that the company that doesn't have insurance is trying to take the fall, and the company that does says it's the other person. So that does look a little bit inconsistent. The other thing I would say, Mr. Scott, is your client, if there is a judgment against them, obviously that, if they have assets that can be executed on, that's something they should be concerned about. But good luck, guys. Hope you guys work it out. And once the mediation is done, if you want to try to reschedule the summary judgment, you're welcome to do so.
Your Honor, I have sent you a proposed order granting the continuance. Did you want to sign something, or what's your?
Did you email that to my court coordinator?
I e-filed it.
Okay. Let me see if I can find it. When did you e-file it?
The 6th, I believe.
Yeah, I see it. Okay. All right. Well, everyone be reasonable during this mediation. I hope you guys get it worked out.
Thank you, Judge.
Thank you,
You
Your Honor.
guys. Good luck.
Bye-bye.
Thanks.
Okay, we're at the day of judgment on this, on y'all's case. Is everyone here that needs to be here for the 10 o'clock case?
Defendant is here, Your Honor.
And I'm plaintiff. We're here.
Is there anyone else that's, that you're waiting on? Because I think we're a little bit early.
Mr. DeFrang was never, he was served and was basically, got a default in the jury award. He's never shown up for anything, Your Honor.
Okay.
And of course,
All
I
right.
have Mr. Gloina as co-counsel, but I've largely been representing myself, and I'm arguing today's motion.
I guess that's kind of what I was going to ask is, is he going to be here for this hearing? Did you need to wait for him?
He will not be here for this hearing.
Okay. Sounds good. Let me just, before we get started, we have quite a few hearings at 10, so let me just check. Mr. Cabrales? Are you there, Mr. Cabrales? Oh, you're muted.
Good morning, Judge. I'm here and I can hear you fine. Are you able to hear me?
Yeah, I'm able to hear. We're about to start a fairly long hearing, and I was just wondering what you were here for.
I believe I am part of the Smile Direct HPI matter. I think you had scheduled a scheduling conference.
Ah,
And
do-
Joe Cox will be the lead attorney for our side, and Philip Sampson, who I think is on as well.
have you guys reached an agreement? Because if you reach an agreement, I can release you as to a trial date. But if you need my help, then you'll have to kind of wait behind the other hearing.
Let me find out. Philip or Joe, can you update us on whether we've reached an agreement with the other side on scheduling matters? You're both on mute.
Good morning, Your Honor.
Yeah, so do you guys have an agreement as to a trial date, or are you going to need to have an actual hearing for this?
No, Judge, we do not have an agreement as to a hearing trial date. We're about 5 months apart from what we proposed and what they have proposed.
Okay, let me just do this then. I'm going to go ahead and deal with this other hearing, then we'll get to you guys.
Okay, great.
Thanks.
Thank you, Judge.
All right, let's go on the record on cause number DC 1811117. Tiambe Jones, I can never say your last name, Adegboyega.
Just Jones, Your Honor. I go by Jones professionally.
Okay, sorry. Versus Joseph Forst. Counsel, make your appearances.
Tiambe Jones, I'm pro se for plaintiff.
This is Craig Laird, Your Honor, for the Farishes and the Farish Family Trust.
Okay. We're here on a motion for judgment. Let's go ahead and hear the argument.
Thank you, Your Honor. On March 10th of this year, the jury trial came to a conclusion with a verdict on this case, and which we had gone through before because of the virus and other issues. We were able to get this hearing now, and we have filed on March 19th our proposed judgment, Your Honor, and we believe it, and because of the dealing with real property and all, the only thing that I apologize, Your Honor, I thought this was we attached a property description exhibit with the judgment. We included in the judgment all issues ruled on by the court, including the judgment that Ms. Jones obtained against Mr. Dufresne, and we're just asking the court to sign this, and we believe it conforms exactly.
I'm looking at the docket. I don't, and I may just be missing it. I don't see that an actual judgment was signed. Is that?
No, so you have not. You didn't sign anything.
No, I'm sorry. I'm sorry. There's not an actual judgment that's been filed that I can see.
Oh, well, I have a copy that was file marked with the attached as the exhibit to the motion to enter judgment.
So is the, I'm sorry, so is the proposed judgment attached to the motion for judgment? Is that the deal?
Yes, Your Honor.
Okay, so there's not a separate document. That's what I was looking for. Okay.
No, sir.
Let me see if we have this. Okay, I see what you're talking about. All right. Nancy, I'm about to print something out. Can you go grab it?
Sure.
Okay, let's go ahead and Ms. Jones. So you're just requesting judgment based on the jury verdict.
Yes, Your Honor.
What, Ms. Jones, I saw you filed the JNOV. Kind of let me hear your argument for that.
Okay. Judge, we have basically three major points of contention. The first major point of contention, and we have attached the admitted documents that were previously admitted in the jury trial themselves. But the first major point of contention is that the substitute trustee notarized and acknowledged the document that appointed him as substitute trustee. The case law is very clear on that in Cresswood. I'm not sure if I'm pronouncing that correctly. The court lays out a test that says that if the notary was employed by the transaction, they
It just, so that, are you talking about creosoted? Is that what the case you're citing to?
Yes, did I mispronounce it? Creosote.
I don't have any idea, but it's spelled, I guess, CREOSOTED, wood block paving company versus McKay. Is that the case you're talking about?
Yes, Your Honor.
Okay.
And the test that is in there is if the notary was employed by the transaction, they are prohibited from having competently taken an acknowledgement of the transaction. The appointment of the substitute trustee that is included as exhibit, I believe it's B. Wait. I believe it's exhibit B. I'm sorry, I'm having some, okay, yes, it's exhibit B. If you'll notice, Judge, that that is the actual document that appointed Mr. Putnam as the substitute trustee. He admitted on the stand that, in fact, that the notary public that served on that on May 8th is him. And so our position is that he could not competently have notarized the document that appointed him as substitute trustee. I included, in addition to that, some information regarding the test that's laid out by First Federal Savings as well, because with the test that's laid out in creosoted, it's a hard and fast test, okay? And you look to the four corners of the document itself. Is the notary actually named in the document? Has he been identified in the document? Is he employed by the document? And that is absolutely met here. It is in the four corners of the document. You do not have to look any further. However, just as an additional concern with this case, we also, of course, as the substitute trustee, there was already an issue at the time that he was appointed substitute trustee. So this was not something that was done prospectively, that if possible, you know, one day there might be a default or something like that. He was appointed to handle the foreclosure in this case. And it was immediately active, okay? The First Federal Savings points out that this is the gravity of the job that he has requires impartiality. It requires that the substitute trustee's actions be impeccable, because in this position, I'm sorry, let me just drink some water. I'm a little. He's acting in a dual role in handling the sale of the property. And so it is necessary that he approach that job with gravity. In this case, you have Mr. Putnam testifying on the stand that even before the foreclosure itself, he was already brokering the sale of the property to Nick Hockman, who was an entirely different party that was not involved in the case.
Can you spell that last name?
I'm sorry?
You said Nick Hockman?
Nick Hockman, Hockman.
I thought you said Hoffman. That was my son. I'm like, is my son involved in this? But no.
No, Nick
That's the same
Hockman.
person. Okay.
And these are all things that the substitute trustee admitted to having done on the stand under oath. And so our position is that that absolutely impeaches the validity of the appointment of the substitute trustee, and therefore any foreclosure that was based upon that appointment would be void. The second issue that we have challenged is that the foreclosure was also void because Texas Property Code section 51.0075E lays out the requirements for appointment of a substitute trustee and the authority of the substitute trustee. I'm sorry, Judge. I'm trying. So, but in letter E, Judge, you'll note that it requires that the name and street address for the trustee or substitute trustees shall be disclosed on the notice required by section 51.002B. That is an absolute requirement without which the foreclosure cannot be valid. If you'll notice, Judge, in the exhibits,
Are you there?
yes.
Okay.
So if you'll notice, Judge, in this case, that was not done. The address of the substitute trustee was not disclosed on the notice that was provided to Mr. Dufresne. And for that reason as well, we are arguing that the foreclosure is void. And then our third point of contention is that, our third point of contention has to do with something that occurred at the trial. So if you recall, Judge, the substitute trustee's deed, which is also included as, I believe, Exhibit E in this, was filed with Dallas County at 1:10 p.m. We raised that as an issue because we didn't believe that the substitute trustee had ample time to have done the foreclosure sale and gotten down there and gotten it notarized and gotten it filed. The substitute trustee cured all of that by saying at trial, well, I notarized the substitute trustee's deed, the affidavit. I notarized that before I came to the sale. This is something that he admitted on the stand. His position at the time and the position of the defendants was that that's not a problem. However, common sense would dictate that you cannot testify to, you cannot give a sworn statement as to having performed something before it was performed. And this is not he say, she say. This is his sworn statement under oath in your court. He admitted that he had done that prior to having performed the foreclosure sale. I don't see how you can execute an affidavit on personal knowledge saying that you have completed a sale prior to the sale actually having been done. And so that's our third.
Ms. Jones, because we do have other hearings, let me just ask a quick question of the two of you guys. So from just a procedural standpoint, today was the motion for judgment. I kind of jumped into the JNOV without talking to Mr. Laird. Mr. Laird, do you want to go forward with just getting the judgment signed and then send the JNOV a different day? Because I guess technically the JNOV isn't set for today. Or do you want to go ahead and hear the JNOV now?
I need more time on the JNOV since she's going into multiple issues that I need to provide a written response because I can't hand you, documents, Your Honor.
Okay.
So
let's just do this. Is there any objection to the form of the judgment? And then we can set the JNOV on another day.
I just have one objection, which is that it does not recite anything regarding the bond. And it's my understanding that they've got to have some language in there to be able to release it.
Okay. What do you think of that, Mr. Laird?
I think we're entitled to the bond, and so we need if you can interline you had her post, I believe, a $3,000 bond to enjoin eviction. And so if you can release that to us, Your Honor, that's great.
And Ms. Jones, do you want me to release it to them or to you?
No, not to them and to us. And I don't see the grounds for which they believe that they're entitled to receive the bond.
I think what needs to happen on the bond is really to have, I'll be honest, I've entered hundreds of TROs and dozens of injunctions over the years. I've never really had a case where a party has actually been able to collect the bond. I'm not saying that Mr. Laird, you're not going to be able to, but I've not had a situation where that's really come up. I think the proper procedure on this would be you would file a motion, Ms. Jones, to release the bond, and then he would file a motion he would file a motion to claim the bond. But I think that I can see why there would be a difference of opinion on who would get the bond. And so I don't know that that should be addressed in this judgment either way. It's not.
I think that's why I didn't put that in, Your Honor.
So I just think it needs to be teed up in a different way. So I'll go ahead, if that's the only objection, I'll go ahead and sign the judgment as is. Go ahead and set the JNOV. I know you guys love meeting with me and I love meeting with you guys, but what I would suggest, if possible, Ms. Jones, is maybe you file a motion to release the bond and try to get that set at the same time as your JNOV. And then Mr. Laird, you can respond to both of those at once so we can kind of just get this thing finished. So, but I will go ahead and sign the judgment as submitted by the defendant, and you guys have a great week, okay?
Okay, Judge, can we go ahead and set the JNOV before we leave here today, or?
I can if you guys want to, but I don't know, Mr. Laird, are you?
I've got my calendar. I mean,
that whole thing is the judgment, including the attachment. That whole thing is the judgment, including the attachment. So that all needs to be scanned.
Okay.
And that's a final. Sure. Let me look at dates for you. How much time do you guys want on this? Or when do I run out of plenary jurisdiction?
I think you run out of plenary jurisdiction.
Oh, I just signed the judgment
Okay,
today,
so-
right? So
Yes.
yeah, I have plenty of time. What are y'all thinking?
Do you have any time? Let's see. Say the 4th, 5th, 6th of November.
I'd prefer not that week. I guess I could do the 6th.
What if, I mean, the
wait a
next
minute.
week?
5th, 6th, I'm sorry. Yeah, that would be fine. The 6th is fine. It's possible, it's very much up in the air, that the next week may be my very first jury trial since the pandemic. So
Wow.
I don't want to mess with that week. So, but it will not be that 4th, 5th, or 6th. Does that work for you, Ms. Jones, the 6th?
Yes, Your Honor.
Mr. Laird?
That works for me, Your Honor.
How about, do you want to do 10:30?
Fine.
10:30 is fine for me.
So Rhonda, go ahead and set the JNOV, and if you want to set, Ms. Jones, your motion to release bond at the same time, you can do that.
Okay, thank you, Judge.
Okay, guys? You guys be safe, all right?
Thank you,
Thank
Your
you.
Honor.
And Rhonda, make sure you just text me and make sure you got that.
And you said 10:30 on the 6th.
10:30, correct.
Okay, thank you, Judge. May we be
You
excused?
may be excused. All right, Villanueva versus Spears.
Adrian Bacher here for plaintiff.
Mr.
Apologize, I had
Mum.
to unmute. Yeah, this is Matt Mum here for the defendant. Excuse me, Judge.
So you guys are set for trial, what, next week?
That's correct. The current setting is Tuesday of next week.
So as you can imagine, we're not going, it's a jury trial, I imagine. And so we're not going to jury trial have any jury trials next week. Just to give you the newest information, this is constantly changing, but the newest information is that the jury services is sending out a juror summons on October 14th. There is a possibility, this is not guaranteed, that the 68th could have a trial the week of November 10th. Again, this is a little bit up in the air. If you guys want to be potentially that first trial that we have, again, there's a lot of things that may happen that cause that not to happen, but I'd be glad to set you on November 10th if you guys want to do November 10th or that week, or we can set you at some later time.
Your Honor, the earliest that I have clear, and I know my calendar isn't the dispositive factor, is December 14th, where I have several clear days in the middle of a week.
What do you have? You have jury trial set on November 10th?
I do not have a jury trial. I have, I have one in Fort Worth, but that's getting continued. But we have all kinds of other things. If you want to put it to November 10th, that's obviously a jury trial can take precedence over our other, calendared items, but.
And just so you know kind of how I think this is going to go, again, this is up in the air, is that jury selection, I think this is going to be the case, I think, for a little bit, where jury selection is going to be virtual, and then the trial may or may not be virtual, the rest of the trial. Mr. Baca, what do you think?
I'd rather not be the guinea pig. But it's up to the court.
Well, and let me just say this. I don't think that I would be the first case to do this. This would just be the first case in my court. So I think that Judge Moore is probably going to do one the week before. She and I are trying different methods of jury selection, of virtual jury selection. I'll have a standing order, I think, that'll address this. But Mr. Baca, you have always been one of the bravest people I know. Are you sure you don't want to be the guinea pig?
Judge, as much as I appreciate that compliment.
I'm not going to force you guys to do this. If you want to, I'm happy to set you and just see what happens, because there is going to be a lot of uncertainty, and I can go through all of why that is, it's really beyond my control. I wish I had a little more control over this, but it's just unfortunately not where we are.
Yeah, so, I'm agreeable with Matt that if we want to put it in December, I think that.
If you don't want to do November 10th, then we're looking at January or later.
Okay.
So does that change your mind, Mr. Baca?
I mean, it's up to Matt if it's when it comes down to it.
Well, I was going to say it's Adrian's case, and he was gracious enough to agree to my requested continuance, whether cases are getting tried or not. I would prefer not to be the first one either, and I do have some commitments in November. If you've got other cases you can set that day, Your Honor, I'd prefer to be moved back.
I'm just going to leave it up to Mr. Baca then.
I agree with Matt, Judge.
All right. So we're going to set you on, this case is kind of old. I'm going to go ahead and set you on January 5th.
Can I say one thing, Your Honor? I do have a setting in Paris on January 5th on a case that's gotten moved for COVID twice. I was supposed to go in April originally.
Paris, France or Texas?
I wish it were Paris, France, but it's Paris, Texas.
Okay.
And that one is definitely going to go to trial when it does go. It's an old case also.
Okay, we can move you to February then if you want to do that.
February is pretty darn clear.
How about February 23rd?
That looks great for me, Your Honor.
That's clear for me, Judge.
All right, we'll go ahead and reset you to February 23rd.
And can I interject one other thing, Judge?
Sure.
I think Mr. Baca and I may have both gotten a little confused and missed this morning's 9 a.m. docket call. We thought the notice we got was for this hearing. And if in fact we did miss the docket call and we're supposed to be there.
The docket calls for next Tuesday.
Okay, because I was gonna say, if somehow this case got DWAPed, it was not my intention or his to not.
No,
appear.
no. You guys are set for trial next Tuesday, so
Okay.
don't worry about it.
Yes, sir.
And Rhonda, did you get that? So we're resetting this to February 23rd. She got it. Okay. All right, you guys be safe.
Thanks,
Hey,
Your Honor.
Judge,
You
have
too.
yourself a good one.
Okay, Wagner Werner versus Garcia.
Good morning, Your
Scott
Honor.
Brown.
Yep, Scott Brown on behalf of the plaintiff.
Okay.
And Stacy Glenn for the defendant.
Okay, and you guys are set for trial next Tuesday as well?
Correct, Your Honor.
You kind of are in the same boat as the other folks. Do you want to go on see what happens on November 10th, or do you want to get set later?
I would say no, Your Honor, just because I don't know if we're going to be able to get the deposition of our doctor in time. We had it scheduled for this month, but we kept running into conflicts. So that's what we were asking for February 9th, if that would work on your end.
That's fine with me.
Okay.
I was going to say, Mr. Brown, you're the second bravest attorney next to Mr. Baca, but you never gave me the chance. So, but yeah, February 9th is fine. Ms. Glenn, does that work for you?
It does, Your Honor.
Okay. And realize that by then, if everything goes according to plan, we will be doing jury trials. So it's going to be, and it looks like, this isn't set in stone, but it looks like it's going to be virtual jury selection, in-person trials. That's what it looks like is going to happen, but that's still a little bit up in the air. So just be ready.
All right. Are we going for
mediation yet or no?
We did. We mediated at the end of August.
Okay. All right. You guys be safe.
You too. Thank you.
Thank you, Judge.
Garcia, thank you. Garcia versus Chapman. Ryan Luna and Rod Kavari. Anyone here on that? HPI, USI, CIB, Hayes Logistics versus Smile Direct.
I'm here, Judge. I'm on, on the Garcia v. Chapa case.
Oh, yeah. Okay.
Sorry.
Who's that?
Dominic Browse for the plaintiff.
Who's talking?
Dominic Browse, Your Honor.
Oh, okay. You're not on here. Were you the plaintiff or the defendant?
Plaintiff, Your Honor.
Okay. When do you want to set this for trial?
We've got, I talked to opposing counsel and we'd agreed to a June 21st trial date. I believe that jives with your court's calendar.
Let me just double check. It would be the 22nd.
22nd.
Tuesday. And this is Garcia versus Chapa, correct?
Yes, Your Honor.
June 22nd work for you?
Yes, Your Honor.
Okay. We'll go ahead and set it on June 22nd. If you want to enter a scheduling order, you can, and I'll be glad to sign it. And if not, we'll just go forward with trial on June 22nd.
Okay, Your Honor, while I have you, we do have a motion for subservice in front of the court right now. I don't know if we need to talk about that now or if you'll get to it when it comes across your desk. Not sure.
Let me just see. Usually I sign this without a hearing, but let me just check this one.
And I guess with the caveat that June 22nd hearing has been agreed to by the one defendant who has appeared, there are two additional defendants who we have yet to be able to serve.
Oh, it looks like you did submit an agreed scheduling order, so I'll go ahead and print that out right now. Is this going to be a jury or non-jury?
We're asking for a jury trial, Your Honor.
Okay. That's fine. Oh, wait a minute. No, I don't know. We just got the jury. Rhonda, do you have the jury weeks? Is that going to be a jury or non-jury week? We just got this scheduled for next year. Jury, okay. It's a jury week, so you should be okay. I'm printing out that, and let me just see your subservice. thanks. Okay. I'm gonna need to, I'm printing that, about to print an order for you. Okay, it looks good. I'm gonna go ahead and sign the subservice.
Thank you, Judge. And again, we expect to have to file a second motion for subservice on the second defendant, which will be forthcoming as soon as we get the stuff from our process server.
Okay. All right, I just signed the agreed scheduling order, set it for June 22nd at 9 a.m. on the jury docket, and I'm about to sign the subservice. So anything else?
That's it from the plaintiff, Your Honor.
All right, you guys be safe, okay?
Thank you so much, Judge.
All right, HPI, USI, CIV, Hayes Logistic versus Smile Direct Club.
Yes, Your Honor. Richard Krumholtz and Alexander Wendt at Norton Rose Fulbright for the plaintiff, HPI.
Judge Joe Cox and Philip Sampson, David Cabrales, Nancy Davis here for Smile Direct. Good morning.
It's a lot of folks here for a scheduling conference, but so there's a difference of opinion on when you guys want to try this.
Yes, Your Honor.
So what does the plaintiff want?
So it may be helpful to understand the background as to why we would like the trial date we've requested.
Sure.
So as I indicated, we represent HPI, the plaintiff in this case. It's a real estate development company. Smile Direct Club is a teledentistry company, an online teledentistry company, and HPI built a 270,000 plus square foot industrial facility in Kyle, Texas. And Smile Direct leased 158,000 plus square feet of that space for over $12 million and had a lease with a term, has a lease with a term of 15 years. That lease became effective based upon the language at the end of 2019, beginning of 2020, this year. The lease payments were paid up through June, but in July, there was rent that became past due and was not paid timely. And in the meantime, Smile Direct Club terminated the lease, or attempted to terminate the lease actually, unilaterally and fairly abruptly. The only real notice that we had that is HPI had was in January or February, that we did notice that the build out either stopped or substantially slowed. And as a result, it left HPI in a very difficult position, obviously. There have been multiple events of default since. This is the only asset of this development company. And so cash flow is obviously a significant concern. We are diligently, that is HPI is diligently trying to release that space per the terms of the agreement and is in negotiations. And we're hopeful over the next 2 to 3 months and fairly confident that it will be released in some form, although probably not on the same terms as the Smile Direct Club lease, given the circumstances. The allegation or the basis supposedly for terminating the lease was the COVID environment and the force majeure provision, or at least the basis was impossibility of performance. You know, we've researched that top, side, and bottom. We don't believe there's any basis under Texas law for that. And I understand, you know, I'm not trying to argue our case here now, and I understand Philip.
Kind of seems like you are, but that's okay.
Yeah, and Mr. Cox would certainly disagree. I don't want to suggest that.
So all I really need to know is kind of what do you need to do?
But we also know that. I'm sorry, Judge.
They want a trial date. Let me just break it down, Judge. We'll disagree with all this stuff. You know we would. They want August of next year. We want January of 2022. They pled this as a level 3 case. It's very complicated. They have to release the thing. They've got to set their damages. They don't even know what they are right now. They want 100, there are 120 hours of depositions that everybody wants to take, or supposedly. So this is level 3. They filed it. 18 months from now is reasonable, and that's what we need. They want to end discovery in April of next year. That's with COVID, who knows what's going to happen. So let's just give us January of 2022, and let's just roll on. We can argue
Judge.
this. If it was a summary judgment hearing, Mr. Krumholtz and I, we could talk about this all day long. But it's just a simple scheduling. We've agreed to Glenn Ashworth as the mediator, and we just think more time is needed, especially for them to develop whatever this damage model is. And they're crying like they're poor, Judge, but they took down 2 million of our letter of credit and put that in their pocket, which we say is wrongful. They owe us 2 million from a build out because my client put in $9 million to build it out. So we can argue about this, Mr. Krumholtz and I can, but the fact of the matter is we think it's going to take longer. They want to try to ram this down on us. And so we'd like some time to develop this, and we need the time, especially given COVID. It's as simple as
Judge,
that.
Judge, that we have agreed on the scope of the discovery. We believe that there's going to be targeted discovery here. It's not a complicated case. It's a breach of a lease that had just started, and we believe we can efficiently get this case ready to be tried. And 13 months from filing, I don't think is unreasonable, even in this circumstance. I tried a case in Delaware recently with a shorter time frame before court and not a jury, but I do believe that deadlines in August of next year will push the parties to get this case moving along and to conclusion, which this client needs because of the cash flow issues. Despite the council's suggestion, there's been a host of damages.
I will agree with Mr. Cox that you said, did you say August is what you were requesting?
It is, Your Honor.
That does seem kind of aggressive for a case like this. How about October?
Judge, we said, I'll give you the background just a little bit. We said January, they said August. We said, how about November? And they said, how about August? And we said, okay, I guess we're not going to work this out. We would agree to November. We can work to a scheduling order and work the dates back. That will work for us. We won't be unreasonable.
Your Honor, September would be our, if we're going to push it past August, as close to August is.
Is this going to be a jury or non-jury?
It's a jury trial.
Jury trial. Okay. Let me see. All right, so 2021. How about October 12th? How does that sound?
Give me a second to pull up the calendar, Your Honor.
Judge, I'm setting federal court that week. I'm going to case with the SEC. So I hate to say it, but I can't do it then.
Okay. How about September 14th?
I was thinking, how about the 18th of November? I mean, of October.
September 14 works for us, Your Honor. And it's probably better because it's not Texas OU following Texas OU weekend. So
okay.
I prefer that.
So how does September 14th look to you, Mr. Cox? What do you think?
Yeah, I prefer October because my SEC case has got all sorts of deadlines in September, and it really just stacks me up. Hopefully a month won't be heartburn for anybody, but I would again suggest October 18th that week or October 25th, whichever one's a jury week for them.
But won't you, if we do it the next week, won't that be right after your other trial?
Judge, it's going to start, it's a 8-day trial that starts on September 4th and goes through October 4th and goes through the 13th. I'll be all right. I just prefer that I just get past September because the SEC and I will be spending a lot of time together in September. But I could do it.
Your Honor, just to be clear, Mr. Cox, you know, I certainly know Mr. Cox and respect him, but Philip Sampson is the lead counsel on this case and has been the only person I've dealt with on this matter who's on the line.
Mr. Sampson, what is your schedule like?
My schedule, as I'm looking at it, Your Honor, or trying to look at it, I am set for arbitration, a 3-week arbitration through mid-September, which means for me, it would be much more convenient to have late September, early October to get ready for this trial and have it set mid to late October.
And your lead counsel, is that right?
I'm co-lead counsel with Joe Cox. Yes.
You only get one lead counsel. Who's
I am lead counsel, Your Honor.
So October 12th work for you, Mr. Sampson?
October 12th does work for me. I understand it's an issue for my colleague Joe, but yes.
So October 12th work for everyone?
It works for HPI, Your Honor.
Okay. We're going to set it for trial on October 12th, and then Mr. Cox, hopefully your other case will get resolved.
All right, Judge, but I'm sure you realize that if we're picking a jury here in Dallas, I'll be the one picking it. So just letting you, I don't think that'll be any surprise to you. So
hopefully by then we'll be back to live jury trials. Who knows? But we'll see what happens.
Your Honor,
let you know. We'll see.
Yeah.
Given the change in the trial date, I think we'll be able to work with counsel on the rest of the deadlines, and we'll propose an order if that's okay.
Okay. We'll go ahead and set this for trial on October 12th then. All right. You guys have a good day.
Thank you, Your Honor.
All right, thank you.
Okay.
Thanks a lot.
Bye-bye.
Thank you, Your Honor.
Thank you, Your Honor.
Lodge 260 LLC versus Overlook Ranch Apartments borrower. Anyone here for that case?
Jenny Martinez with Monk Wilson Mandela for the plaintiffs.
Your Honor, Lee Collins with Boyer Miller on behalf of the defendants.
Okay, so this is a non-jury case, correct?
It is, Your Honor, if I may speak to that, just quickly. I think in all likelihood, there will be a jury demand made, Your Honor. So I think while it is currently postured as a non-jury setting, I think the likelihood is it'll end up on the jury docket.
Okay.
Plaintiffs have not requested a jury. The contract between the parties, I believe, waives a jury. And Mr. Collins and I haven't talked about that, so it's the first I'm hearing of it.
Is there a jury trial waiver in this, Mr. Collins?
Your Honor, if there may be a jury trial waiver, Your Honor, I think, you know, we'll probably have a conversation about whether or not it's enforceable or not, Your Honor. I don't know if that'll come back to this court or not. And candidly, I only mentioned it, Your Honor, because we're talking about pushing out our current trial setting. And so what I didn't want to do is I didn't want to get off of this call and have a conversation about a reset without mentioning that may be an issue.
That's fine. I don't have any problem with that. I just am trying to figure out if this is a pretty new case. And so do we need to reset it on a jury week or non-jury week? If there's a jury, I mean, the Supreme Court has made it very difficult to challenge a jury trial waiver, but I'm not making a ruling. I've just dealt with this a number of times. Let's look at some dates for you. Would March 16th give you enough time?
Your Honor, the parties have agreed to set the trial no sooner than May 10th. And the plaintiffs are fine with that. The typical level 2 is 12 to 15 months in your court. I realize you're doing non-jury trials a little quicker due to the backlog of jury trials. However, we do need to get some discovery in this case. I've just gotten discovery responses within the month and haven't gotten any documents yet. So we would propose no earlier than May 7th, no later than August 7th.
How about June 15th? It's a non-jury week, so what would happen is, I'm kind of assuming that the jury trial, that if there is a jury trial waiver, that typically those are enforced, though, I'll obviously listen to the facts. So what would happen is if that's a non-jury week, so we would set you on June 15th, and then if Mr. Collins is successful in challenging the jury trial waiver, then it would be reset to the next week.
Your Honor, that
15th
date works for the
plaintiffs.
defendants. I'm sorry, excuse me.
Sorry, that works for plaintiffs, Your Honor.
And Mr. Collins, that works for you as well?
It does. I started speaking over Mrs. Martinez, but yes, it does.
Okay. So we'll reset this to June 15th. I would try to, obviously try to get the issue teed up as quickly as you can on the jury trial waiver, and, because that obviously will make a difference on what ends up happening in this case. So, but we'll go ahead and reset you guys to June 15th, and you guys have a great day, okay?
Thank you, Your Honor.
Thank you, Judge. And if I may, I propose that the parties agree to a scheduling order. So
Sure.
it is very clear what the deadlines are.
Absolutely.
So if that is okay with Your Honor, we'd like to do that. Plaintiffs would.
And Your Honor, I'm more than happy to work with Mrs. Martinez on some pretrial deadlines.
Thank you, Judge.
Thank you, guys.
Thank you, Your Honor.
All right. Finally, I think we're done. We're done for the moment. We still have 2 more, but I don't think they're on the line. So good idea. Okay.
It's still on YouTube.
Oh, thank you.